right, you heard it. The speaker asked for this meeting so we could try to help some on the bill. Mr. Willard.
Thank you, Mr. Chairman. This is dealing with Senate Bill 469. As I read the bill really for the first time this afternoon, studying the language, I had concerns about the narrow directive language we have in the bill as it applies to picketing, as it may relate to union disturbances or labor disputes. And I felt we were maybe going outside the boundary of what we could do. I've done some research, not to be a constitutional lawyer, but I found cases that say we have the ability to recognize denying picketing as a use of demonstration at a private residence. The use of it, though, cannot be focused by the law as to a particular type of picketing. For instance, some cases have addressed picketing of a doctor's residence who is a abortion doctor, and that's been found to be unconstitutional. Others have been picketing of a school principal or official about realigning a school district or something. They can't do it that way if it's prohibited. So what I suggest that we are looking at is perhaps two minor amendments to House Bill 469, and I'll be happy to read those. The first one is on line 23. The bill as it came to us has language underlined, which means it was included in the statute 34-6-5, paragraph A, and that language says including private residence. As it reads currently with the language in there, it says, it shall be unlawful for any person to engage in mass picketing at or near any place, comma, including private residence, comma, where a labor dispute exists. So I'm suggesting you certainly have the right to have labor disputes and picketing at a business, but we don't need to have residence stated in there because, again, focuses it only to that type of picketing of business or residence. The second one, Mr. Chairman, is on the second page on line 29, and the current paragraph B of this section reads, it shall be unlawful for any person to engage in targeted picketing of the private residence of any officer, comma, executive, comma, representative, comma, or employee of any entity, comma, organization, comma, then it says, or labor union that is a party to a labor dispute. That phrase, I suggest, would be a appropriate challenge to the constitutionality of the act if we passed it. My suggestion is that we strike out or labor union that is a party to a labor dispute. We've recognized officials and people as far as their private residence in the prior language. The change I make would also include putting an or after entity, and it would read as follows. Starting on line 27, it shall be unlawful for any person to engage in targeted picketing of the private residence of any officer, comma, executive, comma, representative, comma, or employee of any entity or organization, comma, if the intent or reasonably foreseeable effect of such picketing is to interfere with the resident's right of quiet enjoyment or to cause violence or intimidation. I submit and suggest, Mr. Speaker, Mr. Chairman, with that language, we will, I believe, hopefully pass what might be a constitutional challenge to the language because it made it neutral as to the type of picketing. I would move for that amendment.
Second.
The minority leader.
Thank you, sir. To the chairman, I have a couple of questions about the amendment. Is it not true that under the proposed language, the picketing would still be unlawful and would still be subject to the criminal conspiracy and criminal trespass language that increases those penalties fairly dramatically? And under the terms of this language, that would now, instead of simply targeting unions, would target anyone who engaged in picketing, irrespective of the purpose of the picketing?
It makes it neutral as to the purpose for the picketing.
A follow-up question?
Yes, ma'am.
Thank you. So is it correct to say that while this may become constitutional on its face, it still constricts and limits in the state of Georgia the ability of individuals to picket and to protest actions such as the closure of schools, abortion doctors, persons who commit crimes against others. This would limit severely in a way that we have not previously limited our right to protest in the state of Georgia.
Thank you, Madam Leader. By the language, it is engaging in targeted picketing. It would not limit someone or a group by having a protest where they march down the street in a what may be a residential area. They would not be able to go to a particular individual's residence and do their picketing for that purpose because the person may be part of the organization they're picketing.
Mr. Vice Chair.
Thank you, Mr. Chairman. Chairman Willer, just for clarification, and I don't have the bill in front of me, unfortunately, but what we're talking about is those limited situations where it is the intent of the individual or the group, I would imagine, to interfere with the use and enjoyment of one's private residence and or to engage in intimidation under the language of the bill. Is that correct?
Correct, because the courts have recognized the private residence should be a place of sanctity for individuals. They can pick their person's business, or they can pick at the school or whatever they want to do, but they can't go to the residence and do their picketing to cause intimidation to that person in his home.
Thanks.
Family.
Anyone else? The chairman has made us knowledgeable of changes. He has moved on the question. Do I hear a second?
Second.
All right, what the move in the second is for all three things, including private residence or labor union that is party to a labor dispute. Those are the changes. All those in favor signify by aye.
Aye.
Those opposed? The ayes have it. All right, we got another piece of business here. You don't have it on your desk, but there's a governmental affairs substitute. Okay. You have Senate Bill 92. This bill has been stripped out in what we put in 899 that got messed up a little while ago. It has 899, 772, and 776. That's the election code thing. I don't know what's going on. But I need a move. It had 899, 772, and 776 in it. Those were House bills, and all of which we voted on and passed over to the Senate. It was put in one thing. This puts those bills back under SB 92, and I need a...
You got to move.
We got to move. We have a motion. Do I have any discussion? Any opposed? All those in favor signify by aye.
Aye.
Aye. Go back to the first bill and the amendment. You've passed the amendments now. The bill has been sent back to rules. And do I hear a motion for it to be? Do I hear a second? All those opposed signify by aye. All those for signify by aye.
Aye.
It's on. That's it.